As the technical team is getting ready with the PowerPoint presentations, I would like to introduce our two presenters. I'll start with Ms. Daisy Biwott, who is a trainee advocate at G&A Advocate LLP in Nairobi. Daisy is a graduate of Kabarak University School of Law. So she's an alumna of the Christof Heyns Moot Court competition, the 30th edition, that took place in 2021. She has an interest in international human rights law, governance, and constitutionalism. So she has an interesting topic that we wait to be projected. I'll make a comment on that when time comes. The second presenter is Mr. Sidney Tambasi, who is the lead editor for the East Africa at the Afronomics Law Academic Forum. He holds a bachelor's degree from Kenyatta University and has been admitted for an LLM degree at the Geneva Graduate Institute starting this September. He will focus on general public international law with an interest in dispute settlement and a bias for international litigation. So these are our prominent presenters this morning. Okay, it looks like Daisy's presentation is not yet available. Then we'll be starting with Sydney as you are getting ready Daisy's presentation. I would like to mention that we were supposed to be two moderators for this session. I was supposed to do it with Prof. Nkata Murungi, but we agreed that since we only have two presenters, and for the sake of time, I'll be handling this session. So each presenter will have no more than 15 minutes. Then we'll have a very short session for questions. Before we start, I would like to pave this way, because here we are together in this room to discuss human rights in general. And when we talk about human rights, it's not very common that we associate human rights with business. This is a topic that is topical, is very current, is attracting a lot of attention. And there are a lot of legal instruments that have been adopted to ensure that business conduct is actually becomes more conducive or more responsible. I can name here the UN Guiding Principles on Business and Human Rights that actually considered as the foundation of all the discussions. We can also mention very recently the European Union Corporate Sustainability and Due Diligence Directive that was actually adopted this year in April. But in the meantime, we have also the German supply chain. All these instruments that have been put in place are there to ensure that whenever business entities are doing their activities, they have to respect minimum human rights. So the panel that we are having will be discussing some of them, and Sydney will talk about from the imperial character, from the imperial charter companies to the nation states to the corporations, tracing the patterns in human rights responsibilities and abuses. So I will not comment on what he's going to talk about, maybe after his presentation, but I'm going to give him the floor for no more than 15 minutes. Thank you.
All right. Good afternoon, everybody. Pleasure to be here. It's actually good morning. Good morning, everybody. Pleasure to be here. And my name is Sidney Tambasi. As projected here, I will be making a presentation on this subject, what I call from the imperial charter companies to the nation state to the corporation, meaning we've gone full cycle. And in the course of the presentation, you'll be able to understand exactly what I'm talking about. So we are tracing the patterns of human rights responsibilities and abuses. I have to mention that the inspiration came from my teacher, Prof. Ambani, who's been at Kabarak Law School, who first introduced me to this concept, what he calls from company to company. That is to say, I think we can go to the next slide. That is to say that when you look at the outline, that the rulership of colonial Africa, or Africa in general, begins properly with the old company, which I will again talk about. So I'll talk about the incorporation and the insolvency of the company, what I call the old company, and then we gained independence, and at independence we took over our states in self-governance, and we assumed obligations for human rights, human rights obligations, and then now the company is back, but under a different mandate, so to say. We can go next. So the first subject is on the incorporation and subsequent insolvency of the old company. When the imperial powers came to Africa to establish their colonial rule after the scramble and petition for Africa, they first landed on our soil under chartered companies. So depending on which part of the continent you're from, you should be familiar very directly with many of these companies. I come from Kenya, so we were under the British East Africa Company. And next slide. And so the first thing I would like to talk about is the relationship between the old company and the state. And this relationship is dual, so to say. The first is the relationship with the imperium, that is the colony itself, Britain in our case, that chartered the companies and gave them the mandate to come to our soil and pursue their interests on their behalf. And then secondly, with the colony, that is Kenya in our case, or whichever beautiful country you come from. So some of the most interesting features are that, they are given a charter by say Britain, and they are given autonomy to do, mine, do trade, govern, exploit resources. But it's important to note that they were doing this on behalf of the empire. And they assumed de facto governance in our colonies. That means that they were actually in charge of the administration, and it is only much later that when the mandate became so big that then you have the imperium come and exercise direct rule on its own behalf after the company has been declared insolvent, so to say. It didn't happen like that, but just for technical terms, I like to say that. And then, of course, economic exploitation was their primary mandate. We are coming here because the resources, and we are going to get as much as possible as we can from what they assume to be terra nullius, unoccupied land. And of course with military and political backing, because this struggle of economic power was always done at the back of struggle and resistance. So struggle and resistance could only be met by military prowess, which they wielded very strongly. But on the other hand, they also had a relationship with the colony. So the company is here presently. The company is exercising rule. They are getting our resources. Often what is called the native question that I will not discuss, how can we rule over, a majority yet we are a minority. It's been discussed in many other forums. So Mamdani calls it the bifurcated state. They begin by distinguishing between the citizens and the subjects. So the foreigners are the citizens, the natives are the subjects. And it's done very, very properly. We talk about native reserves and all of that. It's things we are familiar with. And more importantly to human rights is that they did not have human rights obligations. So in the nature that we know of, of the obligation to respect, protect, fulfill, they didn't do this because the subjects, who are us, the natives, did not have human rights to begin with. So it's different, you'll see when I talk about the new company. But then after their rule is over, then we move now to independence. We can go to the next slide. We move over to the creation of the post-colonial state, which is epitomized by self-governance. So the rulers who are given this mandate to take our countries to the next level have been educated and schooled in the ways of the colonizer and through their instrumentality of the old company, which is that they have no human rights obligations. The people they are ruling over do not have rights to begin with. But then something interesting happens is that around the time we begin to talk of independence from Ghana all the way to Kenya, Tanzania, and so forth, this is around the same time that we are having more serious conversations on the establishment of human rights instruments. So what we call the age of human rights. You have the ICCPR, the ICSCR, and you're talking of serious social, political, economic rights that are coming into force. And I'll not spend a lot of time here, but to me, when you look at their schooling, so to say, in terms of rulership, and then the obligation that they take over, you understand their struggle when it comes to these kinds of obligations, and it's no way to chastise or sanitize what they are saying. How the states have struggled in terms of human rights implementation. But we properly now establish the tripartite typology. We say you have to fulfill, and you have to respect, and you have to protect at the same time. Next slide. But then over the years, so the company is dead, the company is gone. We know that the states are in charge, but I mean, for students of history, it's very clear that at the end of colonialism, we begin the neo-colonial project, and the company comes back. But this time, there are fundamental differences. Some similarities, some fundamental differences. For instance, the amount of capital and economic prowess that they wield, not only on the developing states where they do a lot of their, a lot of their activities in terms of resource extraction, but also on the states that they have been incorporated. And so they are not an agent this time, they are pursuing their interests, and of course subject to regulatory compliance, and which began with corporate social responsibility, but now we are moving to business and human rights more seriously. And then the second, we can go to the next slide. The second relationship is with the state of operation. So which is the subject, for instance, of this competition. And I will lastly just talk about, when I conclude, about the relationship of, say, MD Limited and Rantania, a proper epitomization of what the new company looks like. And of course, now we are calling them out. We are saying now we have rights and you have obligations, and you have to be accountable to whatever activities you are doing on our soils. And but then what happens is that they are being met by a new challenge. Yeah, they are being met by a new challenge: corruption, capture of the judiciary, capture of the legislature, capture of the executive many times. And so this fundamentally, it presents a new challenge in terms of how, we fully express our human rights, as opposed to how the company, which wields a lot of power, is able to pursue its mandate. We can go to the last slide. So when you look at just, I think we can go to the next one. Yeah, just to contextualize, because the room is full of participants and competitors in the competition. If, say, for instance, the allegations made against MD Steel have some utility, or there is any truth to them, you look at some of the things we are talking about, they are not minor things. If you are talking about things like child labor, we are talking about deaths of children, we are talking about intimidation and forceful eviction from ancestral lands. We are talking about capture of the judiciary. We are talking about capture of the executive. And this is the person you are going against. I think then, again, it's just a clarion call for, for serious deliberations on this issue. Because the person we are going against, and many times the language of struggle and pursuit for human rights is a divisive one. There's us on this side and there's them on the other side. I don't know how true that plays out in reality. But if it is in that very adversarial orientation, then the person we are going against is very powerful, they are very serious, and they mean business, and they have a lot of money. So thank you very much. I hope I've been able to evoke some debate. Thank you.